everybody. My name's Harriet Wessel. I am co-chair of the CLE committee for HYLA. Welcome to October's monthly CLE meeting. We are joined today by one of our HYLA directors, Trevor Deason. So I'm going to hand it over to him. Just before I do, very quickly, a bit of housekeeping. Please remember to self-report your CLE. The CLE code will be released in the chat during the meeting. So please check that for your CLE code. Please remember to self-report your CLE. Thanks very much.
Okay, guys. Hi, I'm Trevor, and we're going to introduce ourselves in just a moment. But I just wanted to start with kind of why we're doing this and what we wanted to do with it. So often in my practice, I am in the position to help sort of new attorneys with their federal cases. And there are things that I've noticed that have come up, sort of reoccurring areas and tips that I sure wish I knew when I was starting out. And so this isn't intended, this is not intended to be a recap of FedCiv Pro, but rather sort of some helpful guides and tips for attorneys sort of entering federal practice, both at the district court level and then also the appellate level. So David, Andrew, and I are together and thought it would be fun to do this and put this together. So that's what we're doing. Okay, so I'm Trevor Deason. I am an attorney at Jones Day. I'm a litigator, and I clerked for the Texas Supreme Court right out of law school. I went to St. Mary's School of Law in San Antonio, and then I clerked in the Southern District of Texas for David Morales, Judge David Morales. I was one of his first clerks. That's actually where I met David. And after 3 years there, I made the jump to private practice here in Houston, and I've been really happy with that. And so that's me, and I'll hand it over to Andrew to let him introduce himself.
Sure. Thanks for inviting me. My name is Andrew Gould. I lead the appellate practice at Arnold and Itkin, which is a plaintiff's law firm here in Houston. I've been a lifelong appellate litigator beginning after my two judicial clerkships, which were much longer ago than David and Trevor. I first clerked for a judge on the U.S. Court of Appeals for the Sixth Circuit, and then I clerked for Judge Lee Rosenthal here in the Southern District of Texas. It's actually what brought me to Houston. And beyond my day-to-day practice, I currently serve as the president of the Federal Bar Association's Southern District of Texas chapter. So I have a very keen interest in all that's going on with respect to federal practice, especially as it relates to our geographic boundaries.
Awesome. Yeah. So, hey, everyone, this is David Gutierrez. I'm happy to see that there are some familiar names as attendees. You know me from HYLA. I am co-chairing a few committees this year, the Nights Out Committee and the Leadership Academy Committee. But in my professional life, I am an associate at Coleman. I've been here for 2 years. Prior to this, I clerked with Trevor actually in Corpus Christi for two judges, Judge Janice Jack and Judge Drew Tipton in the Southern District of Texas. And then afterwards, I clerked for a judge in the 10th Circuit for 1 year. He's actually now the chief judge of that circuit. So it's really good for him. Gets a lot of benefits, I imagine. And I went to law school at the University of Pennsylvania, graduated in 2018. So that's 6 years ago. So I'm still a fairly young attorney, I imagine. So yeah.
Thank you, guys. Yeah, we're definitely blessed to have them here in practice. So let's get started. So you've got your first federal case or your first federal appeal, and you know, some of this is going to be kind of overview and background, but you know, one of the things that it was not obvious to me is, okay, so where am I in Texas? You know, there are four federal districts: the northern, eastern, southern, and western. But within each district, there's divisions. And for example, we are in the Southern District of Texas, Houston Division. And it might not be apparent, it certainly wasn't to me, but every district has its own local rules, and divisions often have specific rules, and even judges themselves will have procedures and policies that they want implemented in their courtrooms. All of these things are potential points to watch out for the unwary and get into binds for not following these specific rules. There's nothing worse than getting called out for either on the docket, your filing is struck, or in courtroom for not following a local rule or judge specific rule. So, this is the overview. You could see the graphic there. The districts are pretty large. We're down there sort of in the purple area, but large span each district covers. And limited jurisdiction, you can't just bring a case in federal court. I think we might all know this, but you have to meet certain jurisdictional requirements. Federal question: are we talking about a federal issue, or is diversity jurisdiction met in the $75,000 requirement? So, and with that, so that's a refresher on the federal Texas district courts, and then this is an overview of the appeals.
Sure. So the Fifth Circuit was created in 1891, the Judiciary Act of 1891. In fact, that's actually when a lot of the federal circuit courts that now exist were created. Now, at the time, right, we're talking it's 1891. Population wasn't then what it is now. And so the Fifth Circuit didn't just exist of Texas, Louisiana, and Mississippi, but also Alabama, Georgia, and Florida. And so from 1891 until 1980, the Fifth Circuit consisted of those 6 states. And as you can imagine, over time, population grew in those states. They're big states, Georgia and Florida in particular. And, there would be more judges. And eventually Congress made the decision to split the Fifth Circuit. And to create what was now the 11th Circuit. So the 11th Circuit was Alabama, Georgia, and Florida. And the Fifth Circuit is Texas, Louisiana, and Mississippi. And so that's the way it's been since 1980. There's actually still discussion. It's been long-standing discussion today. We're not going to talk about it, but the Ninth Circuit is experiencing what the Fifth Circuit, the old Fifth Circuit, used to experience in terms of having an extra large circuit. The Fifth Circuit is next to the Ninth Circuit, the busiest federal circuit court in the nation. And so there are 17 judges, active judges, in total. There are more senior judges as well. And so one of the things that you'll want to be looking out for, right, in your practice is this is what, if you are litigating in federal district court in Texas, Louisiana, and Mississippi, what binds you? What binds you is, of course, there's U.S. Supreme Court precedent, but below that, it's Fifth Circuit precedent. But of course, not all opinions issued by the Fifth Circuit are precedential. That actually distinguishes itself from the state, from Texas state practice on the civil side, where all civil opinions, regardless of publication, are precedential. That is not the case in the Fifth Circuit. Only published opinions are precedential. Unpublished opinions, by contrast, are merely persuasive, but they can be persuasive. And what you'll see in the case law, both within the Fifth Circuit as well as federal district courts, is courts tend to follow Fifth Circuit unpublished opinions if there's nothing else there, but they're not bound to do so.
Okay, so let's move on let's go back to federal district courts. Just talk about the structure a little bit. I'm sure that you all have an idea of this. But yeah, so the district courts, they are trial level courts where federal cases are heard, such as civil rights cases, immigration cases, bankruptcy matters, cases involving federal laws, or cases that are brought under diversity jurisdiction. I think that Trevor touched upon that but earlier, just kind of like a refresher, right? Like, in order to have diversity, you need to have complete diversity of citizenship, which means no plaintiff can be a citizen of the same state as any defendant, and the amount of dispute should be greater than 75,000. So that's kind of like your district court structure. Moving on, bankruptcy courts, also part of the federal system. They operate as more specialized units within the federal district court system. they obviously hear and have jurisdiction over bankruptcy cases and also related matters, such as adversary proceedings, whenever the parties in bankruptcy may have issues or disputes between them. So an adversary proceeding, it's going to be similar to a civil lawsuit. But again, like the issues are related to kind of like the main bankruptcy matter that's simultaneously going on. So bankruptcy courts, they handle most aspects of the bankruptcy or the adversary proceeding independently, although you can appeal their decisions to the district court. So for instance, here, if you're in the Southern District of Texas, you have a bankruptcy matter, you can appeal it to the district court. And in some circumstances, you can actually ask to certify a direct appeal from the bankruptcy court to the Fifth Circuit. So there's a mechanism for that provided in the federal rules. I think it's Title 28, U.S. Code Section 158. So moving on, there are also magistrate judges. So magistrate judges in federal courts, they assist the district court in handling usually pretrial matters such as discovery disputes and motions. They also have authority to conduct hearings with the parties' consent, and preside over civil cases or misdemeanor criminal trials, among other things. So note here, though, and especially for new lawyers, different district courts have different rules or policies on how cases are referred to magistrates, right? So, for instance, in the Southern District of Texas, a district judge may refer any civil case to a magistrate, for the conduct of conferences, hearings, and, procedural discovery motions. But, recently I've had a case in the District of New Mexico, out of state, where, when you file a civil case, it automatically gets referred to a magistrate, for I think like 30 days. And then if you don't provide notice that, you consent to that, it then goes on to the district court. So again, really quirky federal system. We do follow, the federal rules and all that, but, keep in mind that, local rules are really important. And especially with magistrates, you need to kind of like check like what their authority is, and whether, you would even want to consent to actually proceed in front of a magistrate judge. So key differences between federal and state courts to keep in mind. Again, we go back to jurisdiction, right? Because the federal district court, it's a court of limited jurisdiction. And, they handle cases involving, federal law, the U.S. government, interstate disputes, and again, when the parties are diverse. While Texas state courts, as you imagine, will deal with a broader range of cases, including state law violations, family law, property disputes, you name it. So practically speaking, at least at my firm, we generally handle a lot more state court disputes, especially in the oil and gas space. Just because, if you have two Texas companies going at it against each other, like you're just going to go to state court. So in the off chance you do get to federal court, just keep in mind that there are, again, different rules, different ways of proceeding into litigation. Just a quick note on judicial appointments. As you know, federal district judges are appointed for life. They are nominated by the president and then confirmed by the Senate. Texas state judges, on the other hand, are elected for a fixed term. Federal magistrate judges, they are appointed by a majority vote of the active district judges, of the court or of the district court that they're in, and they usually serve an 8-year term. And it's kind of similar to bankruptcy judges, but they're appointed by a majority of the judges of the federal circuit court, right? So not the district court. And they serve 14-year terms. Again, keep in mind that, when you're in a federal court, the federal rules of civil procedure apply along with the local rules, while in state court, they follow the Texas specific procedures. So that's something.
Can I jump in? And there's one other thing too that I think is important about the differences between federal trial courts and Texas trial courts in particular. And I think as you heard us in each of our introduction, we all three of us clerked for this, for a judge on the Southern District of Texas. All federal judges are allotted a certain number of law clerks. On the district level, it generally is 2 to 3. And so, these are typically newer attorneys, sometimes in my case, immediate graduates, right, who are coming and they are assisting the judge with legal research, writing the opinions, and so on and so forth. On the Texas, on the state court side, on the trial side, there are no guaranteed law clerks. Most judges don't have, a law clerk or a staff attorney. You'll find that some, they have a certain budget, and so they can decide how they use that budget. And so, I've been in, for example, in Travis County where, the judge will have one dedicated staff attorney. But, specifically in Harris County, when you're appearing, it's just the judge who's deciding everything by himself or herself. And so that's also something, that is a key difference. It's not to suggest that the law clerk all of a sudden is smarter than the judge, not at all, but just that that's an extra set of eyes working on a case that sometimes the state system doesn't have.
And that's actually a great point to bring up, Andrew, just because, at least like the advice that I've gotten, at my firm and other older practitioners is that, when you're in front of a state court judge, especially, someone like in a smaller town or smaller city, it probably or most likely will not have clerks. So kind of like the brevity and like conciseness of writing briefs, matters way, way more just because, like there's a single judge and he or she probably doesn't have time to, read a 30-page brief with like 100 exhibits. So again, conciseness is important even in the federal system, but keeping in mind that the lack of clerks in the state courts, like that's a big issue, especially when you're drafting a motion or drafting an MSJ. So
Great point. Great points, guys. And not to make this a CLE on the business courts, but I think they might actually have law clerks. So just a point there I wanted to add. Great points, guys. Okay. So moving on, I really like this slide. It may come across as basic, but it sure was not to me. And a couple points here. So, let's say you've got a federal case. A client wants you to file a federal case, or maybe even you're on the defense side and you've got to figure out if you've got to get an answer or an MTD on file. You've got to do something to engage the court. Well, you can't do any of that. You can't even file a notice of appearance unless you are admitted into that district. So that can be, there has been times in my own practice where a case is plopped on my lap, the answer is due in a couple days, I'm not admitted into this district. What can I do? I might be in some trouble. Well, two things. One, you can always pro hoc vice in, and that's for those who don't know, that's a quick, temporary, one-time admission into that particular case in that particular court. And that's always available. I will say you can generally only do that so many times in a particular district before I think they start asking for you to be fully admitted. And so that's option two. And I highly encourage you, even if you don't practice much or at all in federal court, I highly encourage you to get admitted into all the Texas districts, Southern, Northern, Eastern, and Western, and even the Fifth Circuit, which Andrew will talk about in just a second, just because it's so valuable to be able to say, yes, I can take this case. I'm not going to have any issues appearing or making filings. Let's go. So a couple points on admissions, though. Each district does them slightly different, but generally there is, you have to be eligible. You have to have a valid law license and be in good standing with your state bar. There's a written application piece. It's generally pretty short, just some questions, and you can find these applications on the district's websites. And then there's also I think every district requires you to have some recommender or sponsor, and it's typically a person that's already admitted into, let's say, the Southern District, and they can vouch for your character and fitness and your ability to practice law. I think you need 2 of those on every single one. And then there's a fee. There's a fee portion, and then at the end too, once you get admitted, you have to take the oath, and that could be in front of a federal judge. I usually like to do that and invite some of my friends or maybe my family to watch or be with me, because it's a formal thing. You're in a suit. You usually go to the courthouse, and it could be a nice thing. And then you get a beautiful certificate. I've got I've got a few from the districts I'm admitted into that you can frame, and it should be good to go for your practice. So just again, keep in mind, you literally cannot do anything in a case unless you're admitted into that district.
And also, as one more practice point on that, you always feel free to ask, help, from your paralegals, legal assistants, and even other lawyers in your firm or organization. I've been admitted to all the district courts in Texas, and I couldn't have done it without, my, help with the team, right? So, as younger lawyers, it's great to know all these points, but at the same time, when you're actually getting admitted, it is helpful to have, a senior person, whether that's a legal assistant or paralegal, to actually, provide some guidance with the process.
So, on the Fifth Circuit, and I'll be very brief on this because we've got a lot more interesting things to cover, but I think one of the main things to recognize is being admitted to a federal district court or say the Texas State Bar doesn't automatically gain you admission to the Fifth Circuit. You have to apply separately for admission to the Fifth Circuit. In fact, you have to apply for admission into any separate circuit court. So for instance, I'm a member of, I think, a majority of the federal circuit courts, because anytime I appear there, I just go ahead and I just go ahead and fill out the application and pay the admission fee. It's pretty nominal. It's generally only a few $100s. And so you'll see the forums online. It's very self-explanatory. The one thing you need is you will need a sponsor. And that sponsor is somebody who is currently a member of the Fifth Circuit Bar. So talk to your friends, talk to your colleagues. I'm sure you know of somebody who's admitted in the Fifth Circuit, because you'll need their signature as well on your application.
All right, so federal district court jurisdiction. We've touched upon this a few times now. We're just going to reiterate really quickly. So yeah, subject matter jurisdiction, right? It's the power of a federal court to hear a specific type of case. And federal courts typically have power over two matters, like federal questions. When federal questions are involved, that's federal question jurisdiction. And diversity jurisdiction. Again, like those are cases where the parties are from different states and the amount in controversy exceeds $75,000. So in addition to these, federal district courts can also hear cases where the federal government is a party. There's certain bankruptcy and admiralty cases in other specialized areas as designated by Congress. If a case doesn't fall in any of these categories, you're out of luck. You need to go to state court. Removal. So to remove a case from state court to federal court, the defendant must establish a valid basis for federal jurisdiction, right? So it needs to be a case where the plaintiff could have brought the matter initially to the federal court in the first place. And in order for you to remove it, it also needs to be clear on the face of the complaint that there is diversity jurisdiction, or that there is some sort of jurisdiction that the federal court can exercise. So the notice of removal must be filed in the appropriate federal district court within 30 days of receiving the initial complaint. And all defendants, if you have numerous defendants or many defendants in that case, they must consent to the removal. And then the removing party must also include copies of all relevant state court documents and notify both the state court and the opposing party after the filing. Remember too, again, like the case cannot be removed based on diversity if any defendant is a citizen of the state where the action originated. So one advice on that, and this was kind of like a case that we had early this year, is the complications of LLCs and trusts. So we tried to remove a case from state court to the federal court, but our team had challenges alleging the specific citizenship of the LLC plaintiff, right? Because like the LLC apparently, well, now I know the LLC is the citizenship. The citizenship of an LLC is the citizenship of all its members, and for a trust, its citizenship is also determined by its members and beneficiaries, But there's also a rabbit hole where there are certain types of trusts to which their citizenship depends on their trustees. So because of like that challenge of us trying to allege like what the citizenship of an LLC really was and what the citizenship of the trust really was, like in that case, the court sua sponte ordered us to show cause why we had diversity jurisdiction and why shouldn't this be remanded. So again, a pro tip, if you're dealing with removal, it can get a bit messy, especially when you're dealing with like those different entities with a lot of members and a lot of owners. So just keep that in mind. And Trevor, did you want to do supplemental jurisdiction?
Yeah, and I just want to add one tip on removal while we're here. So one thing that I've noticed always gets me in trouble is when you remove Rule 81C2, Federal Rules of Civil Procedure, has sort of a three-step tier process for determining when your responsive pleadings due, your answer or your motion to dismiss. And it could be pretty immediate. So if just removing the case, there's still more steps you need to kind of think through of what happens, what will happen next, when is my answer due, and the like. So again, that's Rule 81C2. Definitely got in trouble in my own practice for not being aware of that rule. Okay, supplemental jurisdiction. Everybody hears about this, and I understood it in law school, but then in practice, it's actually much different and often can be litigated and fought heavily in motion practice. So basically, again, federal courts are limited courts of jurisdiction. You can't just bring any claim, but often, especially in diversity cases or some tort case that touches on a federal question, perhaps there are state claims, and typically those can't be brought. But if the claims for which jurisdiction is proper is part of the same transaction or occurrence of events factually, then the federal court can, of course, hear those state court claims. But one thing you want to watch out for, it can't be supplemental jurisdiction. It can't be used as a weapon. So, for example, a person can't tack on a supplemental claim to try to defeat diversity. That's not going to work. So just keep that in mind. And the overall idea is we don't want to have litigation going on in two different sort of forms. So like the federal claims are being litigated in the federal court, while the other claims, state court claims, are being litigated in state cases. And that happens, and that can happen. But generally, we want to try to keep things together where it makes sense. So just something to keep in mind.
Okay, so as a new lawyer and an associate at your firm or organization, there are certain rules, again, to keep in mind when you're in federal court and you're helping your team, draft answers or complaints or motions. We can go through certain common rules here just to give you a heads up. So Federal Rule of Civil Procedure 8. So Rule 8, that is that involves the actual complaints, right? So in federal courts, the rule requires that the complaint contains enough factual allegations to make the plaintiff's right to relief plausible, right? So it's not a notice requirement. And this effectively means that the complaint must state a claim that is plausible rather than just making conclusory statements. So you can't just kind of enumerate the elements of the claim that you're trying to present without some sort of plausible allegations to back those claims up, even at the early stage of litigation when you're filing the complaint. This focus on specific or even plausible allegations, it's also in Rule 9, which sets heightened pleading standards for certain claims, especially for fraud and mistake. Rule 9 requires that if you're pleading fraud or mistake, and other things, you need to state them with reasonable particularity, kind of stating who, the who, the what, the when, where, and why of the specific fraud claim or even defense. Honestly, a story that I have with this issue was this: we had this case where we wanted to plead fraud as an affirmative defense, and coming from the state court context, I think the team that I was working with kind of just casually added in fraud towards the end of the answer and the counter complaint, as an affirmative defense, right? Like, we plead fraud. We got dinged on that, I think at the motion to dismiss stage, just because, again, we failed to provide, reasonable particularity on why there was fraud and like how that worked, for us as an affirmative defense. So that's just something to, again, keep in mind when you're drafting a pleading or an answer. Another big rule to keep in mind is Rule 12. That's effectively like the motion to dismiss rule, right? 12B. Rule 12 outlines the defenses and objections a party may raise in response to a pleading. So again, this is a bit generally early, like in the litigation. If you want to complain or if you want to dismiss the case because of a lack of subject matter jurisdiction, then Rule 12B1 is going to be your friend here. If you think that the opposing party's complaint, failed to state its claims with plausibility, then Rule 12B6 is going to be the vehicle. Keep in mind too that if you file a Rule 12B type of motion, right, 12B1 or 12B6, among other things, it will stay the deadline to file your answer until the motion to dismiss is resolved. So an interesting question that I've got here, again, going back to like the removal story, is whether a motion to remand, functions as like a 12B6 when in that if it stays kind of like the deadline to file an answer. If in case, like let's say, you're the defendant in the case, you're the plaintiff in state court, the defendant removes the case to federal court, and the defendant then files an answer with a counterclaim, right? Like, do you file, do you then file your answer to those counterclaims, even though there's a motion to remand that you also filed? So kind of complicated, really like rabbit hole stuff, but apparently there are some district courts that will consider a motion to remand as having the same effect as a Rule 12B. Like they're not in Texas. I think one is in Georgia, one is in like Washington, but they see motions to remand as kind of like in the same spirit as a 12B type of motion. But either way, be sure to consult the case law, consult with your team if you were ever in that unique situation where you're required to file an answer to counterclaims, but you're also trying to remand the case back to state court. So anyways, I will stop with those rabbit holes with remands and move on to federal rules of evidence. 402 is a common one. It's also a big one. It states that relevant evidence is admissible in the court unless a specific law or rule prohibits its admission. So in its essence, right, like while irrelevant evidence is not admissible, relevant evidence is. So like a lot of lawyers use this to kind of object and all that, especially when evidence at trial is involved. Rule 403 of the Federal Rules of Evidence permits the exclusion of relevant evidence if its value is substantially outweighed by the danger of unfair prejudice. Whether it confuses the issues or whether it misleads the jury, where there's some issues with undue delay or waste of time. It's an interesting rule, right? Because as a more senior lawyer once told me, all evidence against you is always going to be prejudicial evidence. So there's kind of this balance to kind of argue, whether that piece of evidence is, unfairly prejudicial. And that's something that's, you can argue with the court and all that, but just again, keep in mind. One last thing about procedural rules, we got to check the local rules whenever we're, writing briefs, filing stuff, going through discovery. Just because, while the federal rules of civil procedure apply, different courts and different judges will have their own specific local rules, their own specific, guidelines and policies that they will enforce if you don't follow them. One recent story I've had was, I wrote a 15-page motion to compel in the Eastern District of Texas, I think in front of, one of the judges there, but, we failed to look at this local rule that apparently states that motions to compel or discovery motions in general, they're only, you can only write them, or the maximum pages would be 7 pages. But we wrote this 15-page motion to compel and we needed to cut it down, like the day of the filing. So, that was kind of like a heavy lift, and, that was something that, we just failed to kind of like take a look at because it was a specific judge's rule. So again, while federal rules apply, I think, young lawyers specifically, like, will need to like look at like those local rules in order to kind of like, be safe and comply with the court's directions. So.
Yeah, and just a note on local rules, most people take them for granted. Oh, it's just a local rule, this and that. But they can be used as good weapons. I mean, there was a situation where the opposing party filed the local rule was you had to file all your briefing and your response to a motion in one filing. It had to be in like one document filed. And this particular opposing counsel wanted to file a notice of his response and then separate briefing that was sort of a memorandum and then attach exhibits and all this stuff that we really thought was improper under the local rules. So we fought it. And you might think, well, that might be a waste of time. The judge is just going to let it in. Well, it was costly for the other side, costly for us too, but we were able to, bind up at least the pleading standard of the case doing that. And if opposing counsel had just followed the local rule to a T, he wouldn't have given us a window of attack there. So all this to say, you can certainly be creative with local rules and they could be helpful, or in David's case might be somewhat hurtful, but if just always local rules.
Yeah, I mean, and it's, I was recently giving a firm presentation to our newer attorneys, not related to federal practice, just to practice in general. And one of my tips was the very first thing you should do is look at the court's local rules, whether that's federal court or state court, because what like David's story shows, and like what David said, it's not something that David and David alone has done. I mean, everybody has a story like that. And so the very first thing you should do, whenever you're in any, once your case is assigned, is look at the judge's local rules. I think about Trevor's, story and what he told. I don't know how the judge ruled on it, and it doesn't matter. But what I can tell you is this: even if the judge denied their motion to strike, I can assure you the judge looked at the party and thought this is sloppy. And you lose credibility that way, which is it's what I call an unforced error. So always, it should be the first thing you do is look at the local rules.
Thank you, Andrew. Thank you. And thank you, David. Okay, guys, moving on. I'll kind of go fast on this one just because we've talked a lot about this, but there is one point I really want to draw out, maybe two on this. In your initial pleadings, a big difference between state and federal court is the answer. And the answer, there's no general denial. So you have to literally answer every single paragraph in a complaint. And if you've got a 50-page complaint or more with 100 or 200 paragraphs, boy, you better like really plan for the time that it takes to do that. And you have to be precise. If you miss a paragraph or misstate something, you might leave a window of opportunity for the other side to say, hey, look, you admitted to this paragraph. Be very careful in what you say in your answers. They set the tone. They really do. And complaints as well. When you draft a complaint, you've got to draft it, as David said, with Rule 8 in mind. And if Rule 9's in play, fraud, you've got to be specific. Otherwise, the other side's going to look at you and go, can I file a Rule 12? Because as a defense, as someone that's often on the defense side, I'm always looking at Rule 12. Can I get the pleadings thrown out? I don't want to do discovery. Can I get these tossed out? And I will be picking apart every single paragraph and seeing if there's any way that I can make a good faith basis for a motion to dismiss or the like. One note on MTDs that I just want to say from my time clerking. There's a academic debate about, you've got 10 pages, you've got 5 arguments. How many arguments should you bring them all? Should you bring 1 or 2? What should you do? And I am firmly in the camp, especially with motions to dismiss, to make them short, make them pointed, and bring only your strongest arguments and do it up front. Because as a law clerk on the other side, when every single case was often had an MTD, Some of them were well done, some of them weren't. And the worse they were, the more work they required from me, the longer it took for me somehow to get to them. And my judge was always on me about it because they really clog up the system. So as a practitioner, if you're going to do an MTD, make it short, make it clean, make it strong. You're likely to get a better ruling. You're likely to get a quicker ruling. And I just wanted to point that out. I think it's important. So.
All right, so let's move on to discovery, which is the most fun part of litigation. So rule 26 governs the discovery process in litigation. It requires the parties to disclose initial disclosures, which would contain certain information and documents really early on in the proceedings, including like the identities of witnesses, the evidence that they plan to use, and any other relevant documents. I believe that you can supplement disclosures to move forward, but I think it's like the initial disclosures must be comprehensive in their own way. As you'll know, like litigation in the United States, it's generally driven by the parties. So Rule 26 and also the discovery rules also require the parties to kind of like talk about discovery plans, enter a scheduling order with the court, and kind of have a conversation with the court with those specific things. Kind of like when is fact discovery going to close, or when is expert discovery going to close? So usually, even though it's an adversarial proceeding, you'd have to cooperate a little bit with your opposing counsel to kind of conduct discovery and have like a smooth discovery process. Along with Rule 26, I'd like to flag Rule 33, which governs interrogatories into federal courts. Rule 33D is specifically useful because it allows the responding party to answer by specifying business records or records that the other party may review, as opposed to kind of just like listing all your answers, kind of like in a normal interrogatory. So Rule 33D is something that you might want to keep in mind if answering ROGs might be more efficient, or even more strategically sound. If you were to just produce business records. So yeah, I just wanted to flag 33D. Motions to dismiss. We've been talking about this for a while now. Again, Rule 12B type motions. These are usually filed again earlier in the litigation, maybe even before discovery starts or while discovery is kind of like starting up. So if you have a 12B1, a motion to dismiss for subject matter jurisdiction, or 12B6, failure to state a claim. It might be wise to do those earlier, just because you may want to like steer clear from really inefficient discovery, costly discovery. But and Trevor, correct me if I'm wrong here, but the filing of a motion to dismiss does not automatically stay discovery, right? So like even though like you have a 12B6 pending, you may still be required to go through the discovery process. You may be served with ROGs or requests for production. Just having that motion out there on the docket doesn't really save you from that. But doing them early will hopefully save you from hopefully like a longer discovery process, if in case you win the MTD. And then motions for summary judgment. So this is governed by Rule 56, motions for summary judgment in federal court. It's a request for the court to rule in favor of one party without a trial, just because there is no genuine disputes of material fact, right? And that the movement is entitled to judgment as a matter of law based on the evidence presented. So this is filed after the discovery process, when you've taken all your depositions, when the experts have provided all their expert reports, and you've marked responsive all those relevant emails and documents that you've received from the other side. So pro tips for MSJs. I always like to say that the brief writing process for an MSJ actually starts way earlier, right? Like when you're actually conducting discovery, because like that's when you're trying to figure out what evidence does the other side have. You're trying to kind of develop the facts that are favorable to your position. You're trying to establish the elements of your claims or defenses, and you're working with your experts, to have the expert reports and kind of like the testimony sufficient enough, hopefully, to win an MSJ. So this is why, I said earlier, like I really have fun with the discovery process, just because, towards the end of like that process, you get to write like this long MSJ or this concise MSJ that will kind of, have all the discovery work that you've done through the months and even years, in, maybe 25 or 30 pages to show that the judge that, you either have established all your claims or all the elements in your claims or all the elements in your defenses, right? So again, keep that in mind, like when you're going through the discovery process, like that it does lead to hopefully an MSJ that will succeed. And like if you get that, you don't even get a trial, right? So that's a pro tip on my end. One more thing, really briefly, are motions to exclude. So sometimes, especially when like the case is expert heavy, you need experts to kind of prove certain elements of your claims. You would need to have experts, and like, those experts are going to be deposed and all that. Parties, when they file MSJs, they usually, or like they generally like file motions to exclude along with the MSJs, just because like they're challenging the other party's experts, right? Like saying that the expert or like his testimony is not reliable or credible, or if the expert's not competent enough. So while you're going through discovery, you got to also keep in mind, you're playing defense with your expert. Like it starts with finding credible and competent experts, and then working with the expert to develop like the opinions and kind of like the testimony that will be challenged in the deposition and maybe in a motion to exclude. So you play defense, but you also play offense. Keeping in mind that when you're in a deposition against an expert, then maybe there's going to be a way to kind of get critical admissions that you might use in a motion to exclude that supports an MSJ, moving forward. So.
Yeah, and then just one brief point on this. So the Eastern District of Texas has very specific rules that you have to actually produce documents with your initial disclosure. That's not typical. So any documents that you may have gotten in the pre-litigation process from your client, you have to produce those in a production. And rules are very clear that you can get into a lot of trouble. I've been on the other side of aggressive plaintiffs' counsels that want to throw that rule in my face when I either missed it or didn't remember it, and then they'll go to the judge, and it could be a costly discovery motion practice fight. You just want to be aware of that. Okay. I'm just going to touch on this one point here. Often in the case, you may be asked to, if you want to refer your entire case, trial included, to a magistrate judge, a federal magistrate judge. I highly encourage you to consider that. Most litigants don't want to do that because they'd rather have an Article III judge, and that's fine. That's completely fine. But often magistrate judges are a little bit more nimble with their own dockets and managing a case, and you will almost certainly get a very clean and well done trial, because they're just great trial lawyers themselves before they got on the bench. That's why they got to the bench, and they'll run a very clean case. And they've most likely gotten to know your case, handling all the pretrial work. So I highly encourage that if you're ever in an opportunity to propose that to your client.
Okay, so trial procedures. We're now at the trial phase of the litigation. I'm just going to go quickly on this. We have bench trials in the federal system, so they're conducted before a judge who makes all determinations of law and fact. So you're effectively trying your case before the judge. A jury trial, you are trying your case before a jury who handles like the fact findings of the trial. So why would you choose one or the other? The strategic difference really lies in like the decision-making process, right? Bench trial will allow for a more focused presentation of legal arguments to the judge. And obviously the judge is a lawyer, like he has experience. Maybe in your case, you want that. Maybe you don't want a jury of your peers. But on the other hand, maybe like your claims or maybe your defenses are probably going to be more persuasive to a jury as opposed to a judge. So, again, it's really a strategic question that really depends on like the case that you are handling. More dire, very briefly, in federal court, it's the process of questioning potential jurors to determine if they are suitable for serving on a jury. So, like the local rules, the federal judges in Texas, like they have like different policies on this, right? Like some judges will do the voir dire themselves, while others will allow the attorneys to actually ask the questions. Sometimes judges are more lenient with lawyers asking questions, in civil cases as opposed to criminal. So just, be sure to know this when you're going through this process. And, like, at least in my firm, and I know like other firms do this, you actually have a, kind of like a voir dire consultant who can kind of like sit with you and the lawyers to kind of like check their answers and kind of like figure out if like this person will help, your cause or not. And that'll kind of inform the team, moving forward in trial. So jury instructions, federal judges, especially in Texas, they require proposed jury instructions that are usually modeled from the Fifth Circuit pattern jury instructions. So be ready for the charge conference where the court will finalize the jury instructions and hear objections and issue rulings on those. And usually you'll see the appellate specialists in this stage involved with jury instructions as, and Andrew, correct me if I'm wrong, like crafting these instructions is usually prone to error, and that's, really appealable, it's kind of like a basis for appeal.
Right. Yeah, that's absolutely right. I mean, it's one of the easiest, ways to flip a jury verdict is that the jury was charged incorrectly, but again, one thing David was mentioning that the Fifth Circuit has pattern jury instructions. These are available online. You don't have to pay for them. You just go to the Fifth Circuit's website and you can download them. They've got them for both civil and criminal cases. The difference between the Fifth Circuit pattern jury instructions and the State Bar of Texas pattern jury instructions in Texas State Court, there's kind of this, we use the pattern jury charges, right? And there's just kind of this presumption, right? That it's almost like an informal presumption that use the pattern jury charge wherever you have one. But there's case law on kind of even from the Texas Supreme Court that says the pattern jury instructions, the pattern jury charges are not the law. So it's kind of more of an informal presumption. It's different in the Fifth Circuit. The Fifth Circuit has a formal presumption that if the court is following a pattern jury as a Fifth Circuit pattern jury instruction, it is formally presumed to be correct. So that is all the more reason not to deviate from the Fifth Circuit pattern jury instructions when you're crafting those proposed instructions.
Yep. So just a couple more things before we move to the next slide. Be aware that federal judges may ask questions to the witnesses directly, even in front of the jury. It's one of like the more substantive difference between federal and state court jury trials. And as a junior lawyer, even honestly, even if you're a partner, like when you're trying a case in federal court, you need to really be mindful of who is in the courtroom, right? Like as Andrew and we talked about, there will be clerks, helping the judge, and they will most likely be in the courtroom, while the trial is going on. You need to kind of keep in mind that the judge also has a case manager, maybe a legal assistant, other people involved, not in the decision-making process, but kind of like in the process where the judge kind of has an impression on you, and maybe the jury has an impression on you as a lawyer. So, to kind of preserve your credibility, to kind of like give a good impression, like you need to understand, like there are certain, characters and stakeholders in the courtroom that you just need to keep in mind of while you're there. One more pro tip, as a junior lawyer, especially when you're doing litigation, at the trial level, you will be tasked to like write a lot of witness outlines and maybe even take a witness yourself. While this is like a trial court thing, this task really starts when you're doing discovery, because usually the person that you're going to write a witness outline for, it's going to be for a witness that someone has taken a deposition before, right? So you kind of like know who this witness is, what they're doing, and all that. And I think like the best advice that I've gotten, and might be conservative, but like someone told me that you never ask you never ask a question you don't know an answer to, right? And this usually applies to people that you've taken depositions before, and then now you're writing the witness outline, like in the trial, right? So if you don't have like the privilege of having a previous deposition of like the witness that you're taking, always just keep in mind that like each question that you ask should be most likely be backed by like some sort of factual evidence in the record, just in case like the person contradicts you or says something that you didn't anticipate, you can always, go back to the record and, clarify with the witness as you, move forward. So yeah, with that, I think we can move on. Unless Trevor, if you want to add anything else.
No, that was perfect. Okay, guys, I wrote in my notes to drop the CLE code on this slide, but we are almost at the hour, so I just want to note it's in the chat. You have to self-report your own CLE, but there's the number. If you have any trouble, you can email me or Harriet or anybody from HYLA, and so that's that. Just there, we won't talk about this slide, and I'll share the deck too for everybody that registered. But there are ways to, amend the judgment, move for judgment as a matter of law, or move from new trial. So I did want to give Andrew some time to talk about appeals.
No, that's okay. And I honestly, Trevor, I was gonna, I think actually we should go back because I was gonna suggest that we could always, keep the appeals, for a future presentation, because I want to make sure that we have time for questions. But it's these some of them are trial motions, right? The motion for judgment as a matter of law are critical. You have to move if you want essentially a directed verdict, you have to move for a directed verdict, and you have to do it before, you can renew it later after trial. But if you don't move before trial at the appropriate time, you can't later renew the motion. And so, it's very important that at the close, of your case, or, let's say you're the defendant in the close of the plaintiff's case, you want to move, you need to make that motion then and there. I'd say on the motion for new trial under Rule 59, sometimes they're required for an appeal, depending on, for example, if you're going to be presenting some type of issue that requires an evidentiary record, but they are not a prerequisite to an appeal for other purposes. So for example, let's say that the judge allowed expert testimony, but you objected to that expert testimony coming and you made your record. You can move for a new trial on that basis, but if you want to just go straight to the appeal, you're free to do so. But again, Trevor, I would say, we can just, answer any questions, because I know the time is short.
Okay. Yeah, and again, we will share the deck, but we had a whole bunch of cool stuff for appeals. There's just a lot of great stuff to talk about this. So with that, we've got a few minutes. We can take any questions, if there is any.
Don't be shy. I'm sure somebody has a question.
I can answer anything about motions to remand if you guys want.
Motions to dismiss.
While we wait, I'll do a quick plug. If you're interested in federal practice, the Southern District of Texas is hosting its biannual bench bar conference on Thursday, November 14th. You can get details about this either through going to the Southern District of Texas's website, or you can registrations actually through the HBA website. It's open to all members, anybody who is licensed to practice in the Southern District of Texas or who has an application pending. It's going to be a great day of CLE on federal practice as well as networking. We'll have many of probably a majority of the federal judges throughout the district here.
Yeah, I actually attended one 2 years ago, and it's great. And they've got, Andrew, you can correct me if I'm wrong, but they've got tables where you can still bring your computer and you don't have to miss any.
Yes. Yes. In fact, I was in the middle of an emergency appeal during the one 2 years ago. So I was guilty of having to do some work while there. So yes, it is very work friendly. And you can always come in and dip out too. People do that as well.
Okay, guys. Well, if there's no questions, we're at the top of the hour. This was really fun. Again, I'll circulate the deck, and if you've got any questions, David, Andrew, and I, we're always happy to talk. Again, some of this stuff was not intuitive to me in my practice, but yes, thank you guys all for joining, and get with me if you need help with the credit or anything like that. Thanks again. Thanks, Andrew. Thanks, David.
Thank you all.